Hello and a very good morning to you all, and welcome to today's EU Clusters Talks. I see attendees are joining the room, so let me give you a very brief overview of what we're going to be discussing today. It's Patents in Europe, a new framework for innovation. As always, my name is Jennifer Baker. I'm going to be your moderator today, hopefully putting some great questions to our extensive list of speakers today, as well as getting as much information from all the panelists as well, and trying to draw everyone into a good conversation. So as always, we remind you to put your questions in as well. Now, intellectual property at its very basic level is what allows companies to make use and monetize and make economic value out of their great innovations. It's something that drives the backbone of the European economy. It accounts for almost half of GDP, these IP-intensive industries, and almost 90% of EU exports. So in a sense, it's particularly important for intangible assets like brands, designs, patents, and data, and that sort of thing. So we're going to talk about that. Now, there have been proposals from the European Commission, new rules around things like Supplementary Protection Certificates, or SPCs, as standard essential patents, or SEPs, as well as compulsory licensing. We're going to talk about all of those today because we know this is particularly important for the EU business research community from EU clusters. Our agenda today, we start as always with Nina Hopman from the ECCP to give us the news on what's happening. Then we will have the team from DG Grow within the European Commission. We have 4 members of the team there who will go through giving us a really good detailed overview of what the new proposals are. Then we will turn into our panel debate. Marcus from the group in DG Grow will stay on for that. So if you've got questions for Marcus or from the other members of the group, he will tackle them during the debate, as we know that some of the members have to go because there are council negotiations. And last but not least, we wrap up as always with the funding opportunities. Remember, you can use the Q&A function to ask questions and the chat function to comment or share links. We know it's early in the morning, but we'd love to hear as many of you as possible to join the debate. So raise your hand and we will give you the floor. If you wish to, you can unmute yourself and activate your camera so that we can see and hear you and you can really have a good conversation with our panelists. We would note that the session is being recorded and will be able to be viewed later on the platform on the website. So I think that is everything that we need to discuss for this morning. Everyone knows what page we're on. We will be having a really good conversation. Remember, please use the hashtag EU Clusters Talks if you want to discuss on social media, which I know many of you do. There will be lots of links, so do keep an eye on the chat as well. But for now, I hand over to Nina to give us the news from the European Cluster Collaboration Platform.
Many thanks, Jennifer, and good morning to everybody. As always, some news from our side that we would like to share with you. First of all, there's a new tool on the ECCP website, the Trend Universe, which is a forecast instrument for EU cluster organizations to get insights into future trends and to help you build strategic competitive advantages. Very interesting. You can explore the different 14 industry ecosystem, what are the relevant trends, make an assessment of these trends and what impact this has on you, on your cluster, and also on other clusters, and get some global data on those trends. The tool is available for all ECCP Pros users, and you can find also an introduction on how to use the tool on the website. So please have a look at this. The next event that will take place is the Clusters Meet region in Sweden on the 15th and 16th of June in the region of Skåne. Here we will meet with clusters and companies, with national and regional public authorities and other business support organizations, both from Sweden and from other EU regions, to discuss clusters as boosters of innovation in different ecosystems. In Skåne in particular, we will look at Skåne's specialization areas and see cluster examples of how they drive regional competitiveness. So if you haven't done so and you would like to come to Skåne, registration is still open, so please do register and be part of the event. There are online discussion groups that the ECCP provides for its users, and we have a short survey that is open to you to see what kind of topics you would like to see in the discussion groups, which are of priority to you and what kind of content you expect for the discussion groups. So if you're involved in one of the discussion groups or not yet, please take this short survey and let us know so that we continue working also to have the discussion online and not just, for example, as in our talk today. We also want to share with you a new cluster solutions library, which is new content for policy support. Here you find in-depth case studies of clusters, how they contribute to the economic transition of regions and how they collaborate with the regional policymakers. You have a very extensive analysis of the role in the clusters in the region, what are the strategic challenges, how they impact the work in the region and how they collaborate with the policymakers. You have videos, text, so look into what kind of lessons the clusters have learned and to get some inspiration to shape your own regional cluster policy. Also, mark your calendars. The next EU Industry Days will take place on the 4th until the 6th of October in Malaga, Spain this year, and it will focus on challenges and opportunities of the green, digital, and resilient transition, on EU open strategic autonomy, the integration of Ukraine into the single market, and how to reinforce the EU defense industry capacity. So mark it a very important flagship event from Europe, and there will be a lot of interesting discussions. And you also have the opportunity to organize a stakeholder session for which you can apply until the 26th of June to bring their own speakers and topics to the table. And last but not least, there's also an opportunity to listen to some SME pitches on energy saving and energy efficient solutions. Within the European Sustainable Energy Week, the EEN, the Enterprise Europe Network, organizes this pitching session of SMEs to showcase solutions that are already available on the market and can be applied in industry, cities, and municipalities for energy saving, to make use of energy, renewable energy sources, and lower the carbon footprint. It will take place on the 22nd of June in the morning at 9:30, and you can register for this event via the website of the European Sustainable Energy Week. And with that, let's listen to the speakers from the EC, and back to you, Jennifer.
Thank you very much, Nina. As always, we have those links to all of those important news events in the chat, so please do make use of that. And remember to keep the Q&A function for our questions and keep the links in the chat. As we go into our presentation, we are very pleased to have joining us from DG Grow, Claudia Martinez-Felix, who is Deputy Head of Unit, to give us that overall and overarching introduction to these new EU patent package, the new rules that will hopefully drive some innovation, drive some economic growth at a time when we dearly need it. So Claudia, over to you. And a reminder, do keep putting your questions to Claudia in the Q&A, and I'll get them to her as soon as she's finished her presentation. Thank you, Claudia. Take it away.
Yes, thank you very much, and good morning to everyone. And it's really a pleasure and very timely to be here with you to present what we are doing in the field of IP rights, and particularly in the field of patents, which, as Jennifer and Nina have already mentioned, are the patents gatekeepers for the critical technologies that we need to really drive the green transition, the digital transition, and therefore we need our inventions, our innovations being well protected in Europe, particularly, as to ensure that your businesses can scale up and can actually get returns out of your investments and also attract foreign investments. And so that's why, and not only if we consider, and maybe next slide, you will see here why, the global context, why IP matters. And we're talking about intangible assets that have reached 50 trillion worldwide. And in the last 30 years, we have seen a huge increase of the total value of a company that intangible assets have. I mean, it's been multiplied by 6, the number of this total value. And therefore, again, IP matters and is very important. That's one of the messages we want to pass. And this is very timely, I was saying, because we are one day ahead of a historical moment. What is this historical moment? Where we are going to be finally, after 40 years of waiting, the unitary patent coming into place in the single market. That means that finally, even if so far it's only for 17 member states, we will be in a position for the companies to make use of a single unified patent application that will not need to go through patent validation in each and every member state. So that will, of course, be a very important development that we are not only welcoming and encouraging for the better use of companies, but also complementing with a number of initiatives that will be presented by my colleagues, and that are the so-called the patent package. Maybe you need to click on the slide so that you can see the whole overall picture. Keep on clicking. Yes, and basically below you have the patent levers. These are the three pillar initiatives that my colleagues will be presenting. Notably because the shortcomings of the existing IP legal framework were already identified in the IP action plan, that it's, let's say, our rule book, on the basis of which we, as Commission, have made these proposals to ensure that we have these well-calibrated IP policies. And this is, again, at a moment where we have the unitary patent coming into force, where we are also having a number of crisis instruments being developed in the aftermath of the COVID-19 crisis, but none of the existing crisis instruments are actually targeting the IP dimension. And this is why now we are also coming with the compulsory licensing initiative that Virginie will be explaining. And of course, we are aiming at completing the single market for technology as well. And that also requires transparency and predictability when it comes to the use of the so-called standard essential patents, and my colleague Marcus will explain. Next slide. And here in this next slide, you will see the what we call very nice competitiveness lever slide, where we have tried to regroup. You have a lot of numbers there, but basically what the current shortcomings are, and what is that we are proposing to amend with each and every of these three proposals. But I will let my colleagues go into depth. And so I wish you a very nice conversation. I'm happy to provide any answers you may have. So over to you, Jennifer.
Well, thank you very much, Claudia. I know that you've really done a kind of a great demonstration there about what we're talking about. But can you tell us, I mean, what are the current challenges for patenting in Europe, and what are these the solutions to? What problems are these the solutions to?
Thank you very much for that question. The current challenges that we see and that we have identified, particularly in the IP action plan, are notably, if I can regroup them, four big challenges. The first one is the administrative complexity and the high cost that are related to, for example, just getting into a patent protection in the whole single market. You have to go to each and every national IP office to get your, for example, European patent that you will have asked to the EPO to get your invention protected. So that means that you have to go to each and every national IP offices. That leads to fragmentation, that leads also to more expensive patent protection, including for the different renewal fees and deadlines events that you have within member states. And this is also applicable not only for patents, but also, of course, for supplementary protection certificates, which my colleague will also explain further. But this top up additional 5 years protection beyond the 20 years patent protection that is granted for pharma products, both for human and for veterinary, and also for plant protection products, because this is what it's covered as part of the SPC, as we call it, Supplementary Protection Certificates, is also completely sort of national base. And so we have a big fragmentation and also leading to legal uncertainty. So this is what we are aiming at addressing, and notably, of course, in the context of standard essential patents, which are those standards that are again, essential for accessing, for example, very important technologies. And I'm talking about PCs, Internet of Things, interconnected cars. I mean, all those important standards that are needed to finalize a product. You need transparency and you need royalties which are fair, that allow basically the producers and the consumers then to pay a reasonable price out of the of those patented inventions. So these are, I would summarize the current challenges, and obviously fourth that I forgot, the centralization now that we will have as of tomorrow, the unified courts for patents, for the unitary patent and for European patents. We will finally have centralized patent litigation, which is currently not the case with the current status quo. Thank you, Jennifer.
Thank you. Yes, a lot of things that, as the Americans would say, seem like a no-brainer if you've got a single market. But you've even mentioned things I hadn't thought of before, like the different timings of when a patent might fall due in different states, aside from the actual burden of multiple applications. So thank you very much. I know you have to run off to other meetings. It's a very, very pointed moment in time for you. So I know you're busy. So thank you very much for joining us, Claudia. We are going to hear now a little bit more about those standard essential patents and about the Supplementary Protection Certificate and about compulsory licensing. So I'm going to hand over the floor now to Lena Pauschenbein, who is Legal Officer from DG GROW in the European Commission. Lena, please give us more detail. We're going to really drill down into these kind of three key areas. So I'll give you the floor first.
Many thanks, Jennifer. So in the presentation today, I'm going to give you an overview of what Claudia already touched on a little bit, the current status quo and the current challenges we found in the EU and the solutions that we are proposing in our initiative. So on the first slide that we have brought with you, just a short explanation. Some of you may already know this, but for those that don't, so what is an SPC? An SPC is an IP right, a sui generis IP right. And an SPC makes it possible, under certain conditions, to extend the duration of patents relating to medicinal or plant protection products. And now, why do we have this? Well, think of a medicinal product. You may, for example, patent your product, your active ingredient, but it takes some time for the product to be admitted to the market. So you will need a marketing authorization. And this takes quite some time. There is lengthy testing involved. And thus we are facing a sort of lapse in between the patent of the effective patent protection, because you may have your patent already, but you might not be able to bring the product on the market. And this is why we have the SPC to compensate for this loss in effective protection. We already do have a framework for SPCs in the EU. There are two regulations, one from 2009 for the medicinal products and one from 96 for the plant protection products. In 2020, prior to our now initiative, we already evaluated the framework there. And our evaluation told us that, yes, the SPC framework is very, very relevant today, but there is still some fragmented implementation. There is some legal uncertainty because you face divergent decisions across member states. And this is also what we picked up in the IP Action Plan. In the IP Action Plan, we said, okay, we want to tackle the fragmentation that we currently have now. And on the next slide that we have here today, we see a little bit of the fragmentations that we have. So currently, if you want to get an SPC, you will need to go to up to 27 different member states because they are granted nationally. They are national rights. Of course, most of the SPCs are not granted in all of the member states. The average that we have here is 20 member states, and the average duration of an SPC is 3.5 years. What we're also facing is that since, of course, tomorrow, the monumental day with the unitary patent coming, there is no unitary SPC to complement that. So we do have this fragmentation that we have here, and this leads to high cost and administrative burden because I need to go to up to 27 national offices and, of course, pay the application fees, pay the renewal fees respectively, and possibly also for representation in all of these countries. So that adds up. And I already alluded to it, we have some legal uncertainty currently in the market. So there are some cases where you will face very divergent decisions across the member states. And this is not just problematic for the applicants, but also think if you were a generic manufacturer, this is an issue because due to this legal uncertainty and sometimes lack of transparency, because you cannot see the SPC status in all of the member states in a timely manner, it makes it difficult to plan when to bring the product on the market. And this already you see here on the blue point that we have here, it does cost a lot more than, for example, in the US if you were to apply in all member states. And we have with the unitary SPC and the centralized procedure that we are introducing, which we are going to look at on the next slide, we project that there will be some considerable savings. And this is, of course, important for our innovative SMEs. We are projecting that you can save up to 100,000 for applications in all 27 member states. And if you're an SME, this is quite a considerable amount. So we want to make the SPC regime more efficient and more predictable and complement the unitary pattern, of course, without removing the current national procedures that we have. So what we are doing is twofold. First, we are introducing a centralized procedure. So if you say, I want to have national SPCs granted, then you can sort of go to a one-stop shop with a central authority. This central authority that we have picked is the EU IPO, but there will be strong involvement of national examiners, because we know currently now most of the technical expertise that we have sits in the national patent offices. So examiners from national patent offices will play a key role when examining the SPC application. At the end of the centralized procedure, there will be an opinion that's going to be binding on the national officers, and they will then grant the national SPCs following that binding opinion. And the second level we have here is the unitary SPC. So the unitary SPC is going to sit on top of your unitary patent, covering the same geographical scope as the unitary patent does. And compared to the other first level, this unitary SPC will be granted by the EU IPO instead. And thus, with having one procedure for that, you can combine the applications possibly. So you can say, I want the unitary SPC, and for those member states that are not yet covered by the unitary patent, I want to apply for a national SPC. You can do that in one application. And so we thus cut costs, avoid fragmentation, and also hope to increase legal certainty and transparency, not just for our innovators, but also for our generic makers. Thank you.
Thank you very much, Lena. I'm checking the chat and my Q&A box. I don't see any additional questions for you that are at this point, but can you perhaps tell us where should people go to find out a little bit more if they want to read some more? And we'll try and share the link in the chat in due course. But if you have any advice, should people go straight to the EU IPO?
So on the initiative itself, we currently have a great Q&A and also a small fact sheet on the Commission homepage, where you can see some fact sheets actually for the entire patent package. And I think this is going to be a really, really great introduction to the initiative.
Great, thank you very much. All questions will be answered. We're not short of answers for the next few weeks on this particular issue, as it's so timely. Thank you again, Lena. We will turn now to your colleague, Virginie Faussol, who is also legal officer at DG Grow, to tell us about the new compulsory licensing element. So Virginie, if you are there, we would like to see and hear from you, and we're going to hear a little bit more about that.
Thank you, Jennifer, and I hope that you see me and hear me well. Thanks. So you can go to the next slide. So I will explain to you what is compulsory licensing and the initiative that we are proposing to create a compulsory licensing scheme for crisis management at EU level. So if you go to the next slide, I will introduce the topic. This is quite a technical topic by some questions to make sure that you understand fully what the compulsory licensing is and what are the challenges that we are trying to solve here. So what is a compulsory license? A compulsory license is an authorization given by a state to a person to use a patent without the authorization of the patent holder. So typically you will have a pharma company Alpha, they have a patent on a vaccine, and then Belgium can authorize a manufacturer to use that patent to produce the vaccine without the authorization of the pharma companies. It's not an expropriation as such because, you know, there is a license. So it means that the company, the pharma companies holding the rights will get a remuneration. There will be a duration and some conditions also to ensure that the rights of the patent holder are safeguarded. So that's what the concept of compulsory licensing entails. And this is something that has been there for a long time, for more than a century. And but we have few EU legislation in the field. My second question is when a compulsory license is needed and when it is used. You need to understand that this is something that is very, very rarely used. Usually you have voluntary agreements, so there is no need for a compulsory license. But in some cases, we can imagine that because the patent owner is not willing to develop a product on the market, or because, you know, there is a crisis and you need a product very quickly and the patent owner is not willing to unblock the right, maybe in those cases where there is no voluntary agreement, you need to rely on a compulsory license to unblock the IP rights and to have access to the critical products that you need and that are protected by a patent. So that's a bit when we would need a compulsory license. And in You See Me Coming, we have experienced some crisis in the last few years. And so the topic was put a bit more on the table, saying, okay, maybe we should reflect on whether the EU has a good compulsory licensing scheme to tackle a crisis, you know, in case voluntary agreements do not work and we need critical goods to address a crisis. And here the problem is that in the EU, we have one piece of legislation on compulsory licensing, and this piece of legislation only concerns compulsory licensing for export purposes. So meaning that the harmonization concerns the production, manufacturing of goods under a compulsory license, but only to export to countries outside the EU. And within the EU, for the EU market, it is completely fragmented. So it's only national laws that regulate compulsory licensing. And the problem is that with these national laws, you have also only a national reach, meaning that, for instance, Belgium can only grant a compulsory license for its market, for the Belgian market. Same for Spain. Spain can only grant a compulsory license for the Spanish market. But if there is a crisis in Belgium and manufacturing capacities in Spain, Spain cannot grant a compulsory license to manufacture product and send this product to Belgium experiences the crisis. So you see a bit the problem. It's not the fragmented national compulsory licensing schemes is not adapted to the single market. And we want to change that also to complement all the EU crisis instruments that we have proposed in the past years. So if you go to the next slide, please. Yes, so here you will see what we are proposing. We are proposing one regulation on union compulsory licensing for crisis management. So we are limiting a bit the scope because we are only talking about granting a compulsory licensing when there is a crisis. We exclude other type of grounds, for instance, because the patent is not being exploited. This falls not within the scope of our initiative. This is really compulsory licensing for crisis management. And you see that our regulation has two legs. The main leg, and that's the first box, is compulsory licensing for the single market. And here our objective is to provide the EU with a union level compulsory licensing scheme that would allow the EU to have one compulsory license for the whole EU market, meaning with one procedures, with harmonized conditions, and that will come on top of national system. So for the national system, if there is a crisis in France, the French national compulsory licensing scheme will continue to apply. But what we want to have is that in case there is an EU crisis, we have an EU compulsory licensing system that can cover the EU territory, and so we avoid the fragmentation and the impossibility for member states to help one each other, the problem that I have explained to you. So that's the main leg, and I will get back to you with a concrete example in my next slide. First, but very quickly, second, there is another leg that you quickly saw. It's just to say that we amended a bit the export compulsory licensing regulation to mirror a bit what we have done for the single market. But that's going very much into the detail, and I propose that we directly jump to the concrete example. In the next slide, please. So here, Let's imagine that a new pandemic hit the EU and that we need vaccines and therapeutics. And we realize that we do not have vaccines in the EU, or we don't have sufficient vaccines, and we really need those. And at the same time, some member states have manufacturing capacities. So in that context, because there is a crisis, there is a pandemic, there will be a crisis mechanism that will be activated at EU level. You know that, for instance, we have two main texts in the EU on health crisis. I will not quote them here, but you can remember that it's the HERA regulations. And here, in that context, you can activate a crisis mode. This is very important because, as I told you, compulsory licensing in our initiative is limited to crisis management. So first, you need to have an EU crisis mechanism in place. It can be the Single Market Emergency Instrument, the CHIPS Act emergency provision, but here, since we are in the context of a pandemic, it will be a text declaring a major health crisis. And in the context of this EU crisis mechanism, discussion will be ongoing on how to get vaccines for the EU citizens. And maybe at some point, the observation will be made that there is no voluntary agreement. And it can be for whatever reason. It can be because you don't know who owns the patent on the vaccines, because it can seem trivial, but sometimes, a vaccine or a product can be protected by hundreds of patents. So it can be that problem first. Second, it can be an IP owner not willing to license its right because it's a foreign IP owner and from not such a friendly country. Or it can be that the licensing terms are unacceptable because it would be too long. So you see, you can have multiple reasons why voluntary agreements could not work. And in that case, if we are in the context of an EU crisis instrument, if a crisis mode has been activated, and if we see that voluntary agreements would not provide the right solution, the Commission can grant, with the help of an advisory body, helping the Commission to determine the conditions and whether there is a need for a compulsory license, the Commission can grant a compulsory license. And this compulsory license, contrary to what exists at national level, will have an effect on the whole EU territory. So it will be adapted to the crisis experienced by the member state, and it will be adapted to the cross-border supply chains. So that's, in a very, very short way, what we propose. And I hope that you have understood the mechanism. And back to you, Jennifer. Thank you.
Thank you, Virginie. I just have a follow-up question. How does it work with voluntary agreements, and what, if you can give us an idea, is the incentive for innovation? I know when things are in crisis mode, we do see innovation, but how is it going to work overall?
That's a very good question, because that's always the question that we get asked on compulsory licensing, because people see it as maybe sometimes replacing voluntary agreements. But here, this is really not the objective of our initiative. Voluntary agreements, they work. And that's why, compulsory licensing is very rarely activated, because even in the context of the COVID-19 crisis, there were no need for a compulsory license because voluntary agreements are faster, quicker, more efficient. But it may happen that at some point, voluntary agreements do not work. And in that case, it is better to have something that is ready than not to have anything and to be fair, to be completely, let's say, powerless. And on the another very important aspect of voluntary agreement, of compulsory licensing, is that it can also incentivize, in a sense, voluntary agreements, because when you think of a big market like China or the US, who have, one federal title, and the EU does not have that, in the bargaining position of the EU can be a bit lower in that case. So it can also maybe help, in a sense, achieving voluntary agreements.
Is it fair to say that we should be sort of thinking of it as a safety net?
Exactly. No, it's exactly that. It's a safety net. It's a plan B. Plan A will always be voluntary agreements, but we always need a plan B, and the plan B should be compulsory licensing.
Great. Look, thank you very much, Virginie. As I know Lena mentioned before, there's a lot online in terms of Q&A and spreadsheets and fact sheets, so people can go there to find out a bit more. But thank you very much indeed for your presentation. We'll turn now to talk about standard essential patents, something very important in the technology area, to Marcus Kitsia, who is also at DG Grow. Thank you very much, Marcus.
Thank you.
I'll leave it to you now to give your presentation, and I know you're sticking around for a little bit, so we may be able to get questions to you on the panel as well.
Of course. Thank you very much. And I would just delve into the standard essential patents, last but not least, the third pillar of our patent package. If I can have, yes. So what are standard essential patents? So basically, patents or patents that protect technology that has been declared as a standard by so-called standard developing organizations. Those standard developing organizations are organizations that are run by various companies, by technology companies that develop such technologies as connectivity technology or audio video technology or other processes that then they are declared as standards to different applications. The majority of those standards relate to connectivity, like 3, 4, 5G, Wi-Fi, Bluetooth, or audio and video compression. Now there are many standard developing organizations, and they are setting standards for different in different areas of technology. But the main thrust of standards relates to connectivity that are mainly applied in the ICT industry, in automotive, like connected cars, and now more emerging the so-called Internet of Things, where you have such things like smart meters, like charging stations for e-cars and payment terminals and so on. Now, the number of SEPs in the world, it's a shortcut of standard essential patents, is only about 75,000. It's a number that, which compared to normal patents, is really small. However, they are important to everyday appliances like smartphones, like laptops. And in one of such laptop or smartphone, there are many standards. As you can see, there are 250 different standards that are in a single laptop. So that leads to us that there's a lot of value behind standard essential patents, and only in IoT devices we expect the value to be at around 300 billion euros. And the importance of the increased digitalization can be seen in the increase of the number of SEPs in the last 10 years, which is sixfold increase in numbers, and many thousand companies operate in the field of IoT, for example, in the EU. Next slide, please. So as you can see, if there are many companies involved and the value is high, of course, it creates frictions. So what is so specific about a standard essential patent is that as a normal patent, which it is, as a basis, it grants a monopoly to the patent holder. The patent holder can forbid the user of a patent to use the patent, and sometimes also get a compensation for it. Now, this monopoly is amplified when the patent concerns a standard, because a product which has a connectivity feature like Wi-Fi or a streaming device cannot operate without using a standard. So a company that wants to produce laptops or smartphones has to use the standards, and this gives the SEP holder an increased market power over implementers, over users of SEPs, and this obviously creates competition law issues, and can lead to market abuse. Now, to prevent this, SEP holders are obliged to commit their SEPs to a license to all implementers that would like to use their standards. And this license, this commitment of a license has to be on fair, reasonable, and non-discriminatory terms. Front. Now, this is only this is clear. The rest of the SEP licensing landscape is rather problematic. First of all, it is the SEP landscape is non-transparent in the sense that we don't know how many patents are there that are really standard essential patents. We have found in our assessment that only more or less, depending on the standard, half of the patents are really standard essential. So that leads to a lack of predictability for implementers of those standards. How much do they have to pay for a license for a 5G or Wi-Fi that they use in their products? This in turn leads to an abusive behavior of the patent holder, or also can lead to a abusive behavior of the implementer, where, for instance, the patent holder, the SEP holder, imposes its terms, its license terms on the implementer, because the SEP holder knows that the implementer cannot not use the technology. So the implementer will have to use the technology, and the patent injunction will prevent the implementer from selling the product. So the implementer will be inclined to accept any terms of a license proposed by the SEP holder. On the other hand, the implementer can just simply use the technology without paying a license, and just letting the SEP holder go through the various court proceedings, only to agree on a license at the very end of the process, which leads in the end to lengthy and very costly negotiations and litigation. The conclusion of a single SEP license can cost the SEP holder or the implementer many millions of euros, and can take around 5 years. Now, these problems have been already spotted by the Commission, or explained by the Commission already more than roughly 5 years ago, and the situation has not improved. That's why the Commission has set out in the action plan that it will propose a framework that would regulate the licensing of standard essential patents. Next slide, please. And this is what our SEP regulation is about. We want to facilitate SEP licensing by increasing transparency and reducing existing market imbalance between SEP holders and implementers. And the SEP regulation should facilitate the agreement on a front license between the SEP holder and the licensee. The proposal would also reduce frictions of SEP licensing that could impair the participation, in particular, of SMEs in innovation, and that might be disincentivized, and given the intransparent SEP landscape and the unpredictability of a so-called SEP exposure. So first of all, the SEP regulation would introduce a so-called competence center, which would be also located at the European Union Intellectual Property Office. And this competence center would be the administrator of a register, and would administer processes that are proposed in the regulation, and would gather information on SEPs, on licensing terms, on different licensing practices all over the world, and in particular would provide SMEs with free support, because SMEs lack mostly the resources to assess information on standard essential patents, and do not have the resources to properly negotiate licenses. Now, the Competence Center will hold a centralized register to which a SEP holder will have to register their patents and provide information about the patent itself and to which standard it pertains, and also they will have to provide information on their licensing policies or licensing programs. To overcome this transparent SEP landscape, not knowing whether the declared SEPs in the standardization process are really essential or not, the SEP regulation will introduce a so-called essentiality check, where on an annual basis a sample of SEPs that are registered in the SEP register will be subject to such essentiality checks, and thereby we would strive to reduce so-called over declarations of SEPs, and SEP holders would have to reveal their true essentiality rate of patents that they declare in those standard setting processes. The SEP regulation would also introduce a so-called aggregate royalty determination, which is a maximum license fee for using a standardized technology, meaning that because SEP holders own so many SEP holders own patents with regard to one technology. So 4G is owned by 20 or 30 SEP holders. Now, it would be difficult for every implementer to conclude agreements with each and every SEP holder, and it would also be very difficult for each and every SEP holder to conclude licenses with each and every implementer. That's why in private practice it is usual, not always and everywhere, but it is usual to have a aggregate royalty declaration or an information about the aggregate royalty. And with the regulation, we will facilitate the setting of such an aggregate royalty, and we would also support companies in arriving at such aggregate royalty determination by providing them the possibility to request conciliators or evaluators to give their opinion on the appropriate aggregate royalty determination. And finally, we will introduce a out-of-court dispute a resolution mechanism to determine the terms and condition of a FRAND license. And this FRAND determination procedure would be mandatory for SEP holders or implementers before they can resort to court and start litigation. And this would reduce the costs of knowing of arriving at the FRAND rate or FRAND licensing terms, and it would also reduce the time frame, because court proceedings are very lengthy, and this out-of-court FRAND determination would last only for 9 months and enable the parties to arrive at a FRAND rate much faster than than resorting to litigation. And that is the SEP regulation. I hope it's been clear. Thank you very much.
Thank you very much, Marcus. Indeed, quite a lot to get through with the standard essential patents, because we need to discuss a lot about the technologies underpinning them, and even understanding fair, reasonable and non-discriminatory terms kind of become a little bit intensive to take in one sitting. So thank you very much for taking us through all that. I see some questions coming in the chat. I would urge attendees to put the questions, if they're to our panelists, in the Q&A box. That's right down at the bottom of the screen. It's a small icon like a speech bubble. If you put your questions in there, we'll get them to the panelists. We're going to try and keep the chat for sharing links and directions to additional information. With that, let's turn now to our panel discussion. We have 3 additional great speakers joining Marcus. So if I ask them to switch their cameras and microphones on, please. We have Athanassios Konstantinopoulos, who is the Chief Scientific Officer at the Chorus Cluster. Joining us from the Pons IP is European Patent Attorney and Manager of the Patent Department, Ana Herrera Arroyo. And last but not least, Eugene Sweeney, Senior IP and Innovation Manager at USA. Thank you very much, all of you, for joining us. Athanassios, let's go with you first. Give us your your take initially on what we see about these new proposals, this new package, and where you think it might be of interest to our chorus, our cluster attendees.
Well, I come from an academic research background. I'm also a founder of a startup, and I am an inventor. So looking at this new, my first reaction to these new rules is that this has been long overdue. I mean, someone mentioned, I think earlier, that about United States, other places of the world. I think you cannot compete unless you are having the same tools and that allow you to compete in these areas. However, I would have liked to see also in Europe this capability or this tool which is available in the US, the so-called provisional patent. Still, I have no idea why such a provisional patent has not been instituted in Europe. It would be a very helpful tool, and certainly I think it's something that should be looked upon. With respect to the other rules, I think we have heard that they come as a response essentially to crisis management. They are needed. However, what will happen, after the crisis? I think, let me put it this way: crisis is not the standard way of operation. We would like to see how the European patent system becomes easier, flexible, and more affordable, accessible for the SMEs that are innovative and want to protect their IP. So from the new rules, I think I keep the capability, let's say, of this compulsory licensing that it is generated, and the reduction of costs that comes from the supplementary protection certificates that will be possible to use. However, I think still for the innovative SMEs, the capability to be flexible, to protect some of their IP and having some time to discuss with other investors, with funding organizations or other companies, is still not there. At a cost that would make sense. And I think that in the years that are coming in front of us, we will have a much larger need to make it easier and more affordable for SMEs and startups to protect their IP so that they can be on the same level field as their counterparts in the US.
Just before I move on to our other speakers, since you, Athanassios, since you raised it, what do you mean by this provisional patent for those of us who aren't familiar?
I mean, let me give it to you in a very practical way. I am a startup or an innovative SME. We come up with a nice idea, but we are lacking some of the funding. In order to communicate this idea with some other organizations or other funding, VCs or larger companies, we need to have it protected. However, to have the protection afforded by a patent, it has a certain cost. So the provisional patent, which is used in the US, gives you the time to establish priority and have 12 months. You have your protection and you have 12 months to safely, let's say, negotiate and speak with potential funders and other organizations. Something which cannot be done in Europe. It's a very essential tool for small companies, innovative companies, startups to be able to use.
Okay, well, thank you for that. We may well bring that into our future conversation. Anna, let me turn to you. In your opinion, what are the current challenges for patenting in Europe? What are we going to see change?
Good morning to everybody, and thank you for inviting Pons IP in the first place to this such interesting webinar. Well, the main challenges we see as from the side of patent attorneys are mainly three. The first one is to achieve funding. Is the first limitation European companies find when it comes to patenting their innovations. This is especially important for SMEs. So this is the first challenge we see. The second challenge is the need of having a harmonized system, not only for patenting, but also for litigation procedures. A harmonized system that reduces the uncertainty associated with the protection process and also with associated with the litigation process. The European Union is already in this career, has already made a lot of efforts to try to achieve this harmonized system. The best example is the European Patent Convention, and then the new unitary patent system. Both of these unified systems are trying to become the European territory more similar to the United States territory in terms of the patentability process and the litigation procedures. So we are already making a lot of efforts from the European territory, and this is a very good thing. And the last challenge we see is and especially for research public centers and universities, is the technology transfer, because there is still a gap between the public and the private sectors. In my opinion, they need to have tools that help them to understand better, to understand between them better. And also there is a gap sometimes in the establishment of agreements between the proprietors of IP rights and the licensees or the collaborators. And for this, it's very important what is being discussed today, because in my opinion, it is needed a legal framework that helps to establish more fair agreements between patent holders and licensees and collaborators that reward the innovation, and at the same time that allow the technology to get the market and to be used by third parties and finally by the final users. So it is important to have a legal framework that help to establish more fair agreements, but also it should be combined with professional assistance to maybe review or help in the negotiations of these agreements. So that's very important. And the last thing I would like to comment is that, in my opinion, there is still a necessity to spread an IP rights culture for the protection of the innovations. Because we are still far from the numbers of other countries like the United States or China or even Japan. So it's very important to to make the innovators aware about the necessity of protecting their innovations to be competitive in the market and to get a good position in the market. And then in relation with the three topics we are discussing today in the context of the new rules, for standard essential patents, as I've mentioned before, it's very important to have a legal framework that regulates in a fair manner the agreements that the proprietors and the users and the innovators have to make. Also, there is important to have, well, I find very interesting the issue with the SPCs, because it's true that this is a very particular case, but there is a lot of market fragmentation. And we see in our clients that while in some countries their SPCs have been granted, not in others. So this creates a lot of uncertainty for the holders of the drugs, of the innovator drugs, and also for the manufacturers of generics. So it's very interesting to have an SPC, a unified SPC to reduce the market fragmentation. And finally, regarding the compulsory licenses, my opinion is that, as the previous speakers have already explained, voluntary agreements should be the election of choice in the first place, because this is the best way to preserve the proprietor rights and to ensure that their investment returns, while providing access to technology to everybody. So voluntary agreements should be the election of choice, but it's true that when voluntary agreements are not possible, it is essential to have regulations that help to reach agreements, or that assure that the strongly needed solution reaches to everybody. Thank you.
Thank you, Anna. You've gone through everything now. We'll try and break it down a little bit. I know it's a lot to get through. Eugene, let me turn to you. I mean, isn't all of this essentially just trying to put cross the T's and dot the I's of a single market, in particular a digital single market? Because we're not China, we're not the US, we have got 27 different member states. So it's possibly not surprising that, you know, it's taken a while to get to this final step.
Yeah, absolutely. Particularly for the case of compulsory licenses and SPCs. They've been around a long time. SPCs are there obviously because to get the benefit of having a limited monopoly with your patent. For some industries, it takes a long time to go through regulatory approval, so it makes sense to extend it. But because these are national regulations, both for compulsory licenses and SPCs, even though in Europe things are pretty well harmonized at a legal level, there are some differences in both the law and in its interpretation. And you gave some examples there where, you know, some territories would grant an SPC and others wouldn't. So harmonizing it across Europe makes a lot of sense in the light of the unitary patent. So I think those are no-brainers. When we come to standard essential patents, I think the issues are slightly different. It's very important, particularly as we become more global and trans-border, not just within Europe, but, you know, worldwide with the internet and so on, that we have to, and we're having technologies like 5G, home entertainment, video compression, that people try and conform to standards. But these are standard essential patents are essentially patents, but they're required in order to comply with particular technical specifications for certain technologies. I think there are a number of issues, and I think the two which have been identified here are the fair and reasonable aspect, and the other one is the essentiality. And at the moment, there isn't really any, in general terms, there isn't a lot of checking to see whether a patent is actually essential. It's declared, but sometimes it's not necessarily verified. It may also expire. And the other bit is this fair and reasonable aspect. How do you know what that is? Because it's licensing is and terms and conditions are different in different sectors. I mean, I've been involved in licensing in the ICT area, and it's very different to what my colleagues do in the diagnostics or medical sector. So I have some concerns about this competence center as to whether they are going to become an expert in all sorts of licensing. The Licensing Executive Society has, thousands of members, all of them, working in different sectors, and it's not something that's easily done. So good luck with that. The other aspect is this fair, reasonable, and non-discriminatory. We're seeing now many patent pools. Patent pools have been around for a while, since the late 1800s for the first ones, but they're growing now as we see technologies like 5G, video compression, and so on. And there are a number of patent pools. CISFEL, for example, run the 5G patent pool, and these patent pools operate in a similar way to what's being proposed here, but of course they're unregulated. They do try and have independent people ensuring essentiality and monitoring the portfolio of patents. They do have an aggregate license, but these terms and conditions are generally market determined. There's no one coming in, if there's a dispute, there may be a dispute, but they'll try and show that they're very independent. So it's almost, I think, down to the transparency aspect. The issue arises when, I think if people go through patent pools, they are transparent. You can go there, you can look at the rates. You may disagree with those terms, but they're generally determined across the market. The issue comes when there's a dispute, and it may be you're trying to license a standard essential patent that's not within a transparent patent pool. And then this scheme will come in, the competence center and the aggregate royalties will all maybe provide some support. But I would say that, patents are patents, whether they're standards or not. And the use of patents is a strategic decision. You should consider patents or any form of IP protection as a legal tool, which may or may not help support your business. And based on that decision, you decide to do whatever you're doing regarding protection. If you're a researcher or creator of technology, it's important that you, as well as understanding the IPR landscape at an early stage, to make sure you're not reinventing the wheel, or if there are commercial opportunities, you won't enter freedom to operate issues. You should also be looking at the standards landscape, particularly in technology areas, internet things, just to identify if there are standards that you should be trying to comply with as you do your development work, or standards that you might want to contribute to in the future, or you may decide for strategic reasons you want to bring your new technology to a standards body to put it forward because you think making it a standard essentials patent would be a good thing, provided, of course, that standard body will accept it. So there are a lot of different issues here for the end users. And again, for the implementers, any implementer will need to do a freedom to operate check, and that should throw up patents that are relevant, which they may identify because they're already trying to comply to a standard. And then it's a commercial decision. If they can come to an amicable agreement, fine. If not, then if they think it's not fair and reasonable, then there's somewhere for them to go.
Well, we have a lot to unpack there, Eugene, so thank you very much. I know there's a lot, and I'm going to ask Marcus to comment on some of that. Sorry, Marcus, not to put you on the spot, but as the remaining Commission representative left on the panel. A lot of things have been touched on here. There was the point raised of the provisional patent. Eugene there raising questions around FRAND and essentiality assessments, and indeed patent pools. Patent pools, do you want to start with that as the low-hanging fruit? It's a fairly non-standard situation when we see patent pools. It's not the status quo. Marcus, take these in whichever order you like, but I'd be interested to hear your thoughts on all of those.
Okay, so yes, let's start with patent pools. There are, of course, patent pools is a good tool. The Commission has been incentivizing patent pooling, but despite all those efforts, it's not an ideal solution, or let's say it's not sufficiently developed, because patent pools are are comprised not of all SEP holders. So it's only a part, depending on the pool. Avanci has 80% of their 4G patent holders, which is good, but on the other hand is only limited to automotive. So it doesn't help if you want to, or if implementers innovate or implement in other areas, in IoT, let's say. Other pools have a much lower percentage of SEP holders in their pooled. So it's a good development, but it's still not sufficient. When it comes to let's say a situation where the market is functioning, or the licensing does not really raises concerns, because it is already let's say very stable. Our proposal is flexible in the same way that the Commission may or will have to determine standards, future standards or existing standards, which can be excluded from the scope of the regulation, and so that we would enter into the market, let's say, and we would only there where it's necessary, where we have stable licensing conditions. We would then exclude applications, implementations, or standards from the scope of the regulation. And yes, essentiality, you raised, it's an issue, and it's a persisting issue, and it grows because standard SEPs are being new SEPs are being put on the market. The number is increasing. There are companies that declare SEPs very generously. There are standard development organizations that allow for so-called blanket declarations, which means that companies just say, yes, we have patents, and not declaring any more information, which makes it really difficult to assess the SEP exposure for companies, and also for other SEP holders that have perhaps a strong SEP portfolios and enter into cross-licensing agreements with other SEP holders, and in reality, they forego their licensing fees because the counterpartner does not have such a strong portfolio as the other SEP holder. And finally, whether the UIPO is becoming an expert in licensing. No, because the UIPO is only the facilitator, the administrator of the process, and the real work, to put it that way, will be carried out by external experts, for which the UIPO is going to set up and maintain a roster of conciliators, of evaluators that are from the market, and they will also be divided in different technology areas, so that we have the possibility to draw on experts in their respective fields. And I think that we have also made our calculations and assessment, and I think there's a sufficient number of experts out there that would be able to do the work. Thank you.
Thank you very much, Marcus. I know it's a big challenge for the IPO. I know because I'm hosting it on the 14th and 15th of June, they're going to have their 5th International IP Enforcement Summit. So I'm assuming that after that, we'll have a bit more clarity and detail as well on how it's all going to work. Eugene, you wanted to jump in?
Yeah, just to follow up on the patent pools, because as you say, they're a good idea, but essentially they're a little bit, they do their own thing. And, you know, as you said, the advantage is you don't have to go to 15 licensees, you know, to get a license, you go to one. But again, there are some areas where there are maybe 3 sets of different patent pools. But I think the problem is that it's not so transparent. They try and be transparent, but they're not regulated, if you like, in any way or approved. And it may be something for the Commission to consider, maybe giving a certificate of approval or some sort of way of saying, yeah, this patent pool is checking essentiality, you know, adequately, you know, that we think the terms are fair and reasonable or something like that, because they're a tool under development, but, you know, not quite there yet, perhaps.
Yeah, well, I mean, we're very early in the days of discussing some of these proposals, so hopefully we will get there eventually, Eugene. Yeah. We've talked quite a lot about what it means for business, what it might mean for innovation. Athanasios, tell me a bit about what it might mean for clusters. Make the link for us with what this means for our EU clusters.
Well, you know, clusters are a very, let's say, new or rediscovered tool for, you know, pulling together resources and especially providing a different environment for SMEs to exchange information, learn, and so on. And I would say that still, while there are not so many SME patent applications in Europe, in my knowledge, the patent landscape is dominated mainly by large companies. Maybe clusters could facilitate the, let's say, democratization of the patenting process for the small companies by pulling together resources, explaining some of the complex terminologies, and also maybe acting on behalf of some of their members into facilitating the interaction with patent attorneys, patent organizations, because as you know, mainly for an SME, the main concern is daily survival, so to speak, you know, in a difficult environment. And many times they lack the personnel or the capacity to really go deep into these issues. So clusters could serve that role in facilitating this, you know, access to tools for patenting and so on. And at the same time, they can also disseminate good examples or even raise, you know, more awareness about some other sectors, because I hear, you know, about the dominant, let's say, presence of digitalization in these new rules and regulations, but we should not forget that a major part of the European SMEs are still in the, let's say, traditional or manufacturing sectors. They are, you know, the locomotive of the economy, and you know, they cannot be left behind just focusing only on digitalization, let's say, on the digitalization landscape. So I think it will be a challenge for clusters to try to, you know, make and explain these new regulations to their members, but at the same time convey to the legislation, you know, some of the real needs of, let's say, traditional SMEs and smaller companies that happen to, you know, to want to be innovative, but they are lacking, you know, the capacity or the tools. In that respect, there is also this particular other subgroup into the small companies, which is the startups. The startups could be in any sector. I think the regulations regarding the pharma and so on, you know, startups in that area would be highly benefited. But you have to keep in mind that for startups, it is essential to have a fast grow path, And this fast growth path sometimes depends a lot on being able to negotiate and communicate what they have with funding organizations. So being able to have some solid IP protection, not necessarily of the same type and kind like a large company has, but just to be sure that they have some freedom to operate or can establish the freedom to operate vis-a-vis their negotiating counterpart. It could be the condition for their survival.
Thank you. Anna, Athanasios mentioned there the intangible goods, I think, as well, I think was the point you were trying to make, are also relevant. I know you have a collaboration agreement with the packaging cluster. Tell me a bit about that. And I also then want to come on to Dominique Delaporte has made several comments in the chat, but also raising the question of trademarks and where that might be a little bit different from what we're talking about. But tell us a bit about this packaging cluster agreement.
Well, what we do with this cluster in particular is first of all to foster the training on IP rights protection, because as Athanasios has mentioned, SMEs are not still totally concerned about how important is the protection for enforcing their rights. First of all, we work fostering and providing this culture, this IP rights protection culture I mentioned before. And secondly, we help them. We help the cluster and the companies that are within it to design the most proper strategies for their protection, for the protection of their innovations, and for the technology transfer. We also help reviewing and assisting in their agreements, in their conversations with third parties. So we provide a global assistance in all the IP matters, from training about the importance of the protection to protecting their innovations, and finally with the designing of the most proper strategies for protection and for technology transfer to reach agreements that they can benefit from.
Thank you. Eugene, let me come back to you. I mean, Dominique in the chat has raised this question about registered trademarks. Can you explain to us a bit about what they are, what the difference is, and what we should be thinking about?
Okay, when we come to trademarks, you can register a trademark, or in some countries you just put the symbol there and it's unregistered. But what a trade or service mark does is identify some quality of your product or service. And a trademark on its own is really just a tool that you can use to build a brand. So if you're going to have a trademark, you have to accompany it with a brand building strategy and invest so that when people see your trademark, they associate it with whatever you want them to associate with it, a luxury good or a cheap good or whatever it is, or value for money, or whatever. So the trademark is important. But you have to, it just won't live on its own. You have to keep it alive and make it work for you. But like any other IP, Anna was talking about helping people with their strategies and what sort of protection is best. There are many different types of IP protection for different types of IP. Patents are for technical inventions. You have design rights, copyrights, plant utilities, and so on. There's lots of things. And the reason you have them is to essentially give you a limited monopoly position, in return for you disclosing details so that you can stimulate innovation. And you would seek to have IP protection in order to enhance your chances of your business developing. And there are a number of reasons. One might be because you want to raise investment. So there are a lot of good reasons for having it. But you should not consider it as a cost. SMEs particularly tend to think of it as a cost, and they often discount patents because they're too expensive. Maybe they're going to be less expensive at a unitary patent. but they shouldn't be thought of as costs. They should be thought of as an investment in order to grow your business, in the same way that you might invest in marketing or sales or other things in your company. And if you put it in that context, then the costs of IP protection are, relatively insignificant compared to the costs of hiring marketing managers and doing marketing. So it's a strategic thing. And as I say, trademarks is one of those, and it's a good thing if that's what you want to do. In certain sectors, trademarks, copyrights are more important. In other sectors, maybe patents are more important. And it's down to the sector, the time to market. If you want to build market dominance and you're not going to worry about, you don't have patent protection, then you ought to have a good branding strategy to support your trademark.
Thank you, Eugene, for taking that. I know there's a lot of questions from Dominique in the chat. We won't really be able to get to all of them as they're very specific. But I also have a final question that was sent in, emailed in actually before today's event, asking whether you consider that the patent trends of the ICT sector, standard essential patents, the pools, the patent troll question, which is not something we've had time to address today, could be extended to other sectors, for example, the other industries, pharmaceutical and so on. Any thoughts on that, Eugene, before I ask for a final wrap up from our other speakers?
I mean, a lot of the standard essential patents are to do with interconnectivity. Whether you're, and where you have, even if you look at the automotive sectors, you want to get into a car and, expect it to behave the same. And the same with, anything you plug in, plug and play phones, and they all, at the moment, are tending to be in that sector. With pharmaceuticals, I can't see that happening. It may exist in other manufacturing sectors where you want to have some common ground, so you don't have to reinvent the wheel every time. But I think is what the market will decide. Yeah.
Thank you very, very much indeed. Anna, let me ask you for a final takeaway thought. What should we be bearing in mind? I mean, there's still some work to be done, but what should we be looking out for?
So could you repeat the question?
Just give us a final takeaway thought on what people should be bearing in mind as we look towards the development of how these new proposals are going to play out in practice.
Yes, well, I think they are very, very interesting measures. The initiatives are very, I think as a first thought, they are very useful. They can be of help in the disputes and for reducing the market fragmentation. But anyway, we will need to wait to see how effective these measures are in practice and how the different industries take advantage of this, and what are the thoughts of the different sectors of industry. And then after a few years, maybe after a few years of implementing these new rules, we will need to review what change should be made in view of the ongoing process of implementing them.
Thank you. And then final word, Athanasios, for you, where are we going? Are we headed in the right direction? Just a very brief wrap up.
I think we are heading in the right direction. Of course, the question is, as Anna said, this has been long overdue, to speed up the process, make it more efficient, have a lower cost. All these are essential elements. But, as they say, at least in my profession in chemical engineering, it's not only about thermodynamics, it's about kinetics. How fast can you do it? And can you do it faster than friction or dissipation that happens, anyway in a system that has competition from other actors. So, the verdict is it will be seen in practice, but certainly this is, the right direction to move.
Athanasios, Anna, and Eugene, and Marcus as well. Thank you all very much for this interesting discussion. I know we've gone a little bit longer than usual today. I see there's also been a question in the chat from Vitaly that was put in, unfortunately, when Virginie had to leave, but I'm putting into the chat there, Vitaly, somewhere you'll be able to find out the answer to that question on compulsory licensing and questions around in time of crisis, how we manage. thank you all again. Thank you for the questions. I'm going to turn now over for our very last minute to Nina once again. Nina, a whistle-stop tour, I think, through the funding opportunities.
Yes, many thanks to everybody for the very interesting discussion and trying to follow to the best of my knowledge. Thank you very much. What we want to share with you is a call for regional innovation valleys, which is a new initiative and I think very interesting to what was also discussed about innovation for ICT solutions here. The focus is especially on the potential of deep tech innovation. The regional innovation valleys should strengthen and advance European innovation ecosystem, connecting EU territories and foster stronger cohesion. There are two ways of becoming a regional innovation valley. The first one is express your interest in the call for expression of interest that is published, and you can do that until the 18th of September if you're a region, because this is especially for regions eligible under the NUTS 1 and NUTS 2 level with clusters and other stakeholders as their collaborators in the regional innovation valleys. The goal is to identify up to 100 regions to enhance the coordination and direction of their research and innovation investments and policies. You can find more infos on this in the chat. And the second option to become a regional innovation valley is through a call that is called Interconnected Innovation Ecosystems. The same, create connected regional innovation valleys, with the topic primarily focused on regional aspects of innovation and target national and regional innovation authorities. For example, clusters, research institutions, universities, they can participate in the consortia as associated partners. And the aim is to create efficient, open, inclusive, and interconnected European innovation ecosystems. The call is open until the 17th of October. The topic ID is in the screen and the link to the call in the chat. Regarding the topic of today, there's also an upcoming call which will open on the 6th of December this year. So if you're interested, you have some time to prepare on capacity building on IP management to support open science. Projects should contribute to an analysis of how adequate IP management enables and boosts open science, develop specific training materials, high quality training, gather good practices, plus a raising awareness campaign. It's a Horizon coordination and support action with the topic ID in the screen and the link in the chat. And last but not least, we also remind you for opportunities for SMEs. There are calls from Europe clusters currently open in different industrial ecosystems, for example, in the life sciences, in agri-food and energy intensive industries, textile, blue economy. You find all the different calls that are currently open that either close, some of them today, but most of them in June and July on the European Cluster Collaboration Platform. So if you click on the link in the chat, you will get to all the open calls from the Euro clusters that are available to SMEs. Thank you, and back to you.
Thank you very much, Nina. A lot of calls there, so please do click on the link and check them all out. As always, we urge you to continue the discussion. You can use the hashtag EU Clusters Talk or go to the general discussion group there on LinkedIn. Register for the next talks on the 14th of June. It will be skills for cluster managers. On the 21st of June, it's a very trendy session. It's the special session on the ECCB trend universe. And on the 28th of June, there's a Euro clusters discussion. So choose which one of those, or indeed register for all of them through the European Cluster Collaboration Platform. To find your way, we'll show you there the QR code on the screen. It's the European Online Hub for all your industry clusters, and you can find lots more information there. And we hope we will see you again at one of the talks soon. So thank you and have a great day.